So we're going to talk a little bit about the Supreme Court decision initially, and then we'll get through how it affects employment, how it affects some of the decisions that you're going to have to make as employers. So just a brief overview. I think a lot of people are aware of this, but Students for Fair Admissions versus Harvard and a separate case against UNC resulted in the Supreme Court's review of admissions policies under the 14th Amendment Equal Protection Clause, which says that essentially people should not be treated differently based on their race. And it found that admissions policies that take race into consideration violate the Equal Protection Clause, which is different than we've seen before. We'll talk a little bit about prior precedent, but there's been some consideration of race that's been permitted in college admissions for the past 45 years. And that is to some extent not allowed anymore, although there's a potential loophole that we'll talk about at the end. Don't know why this is not advanced. There we go. Okay. So first, let's talk about Harvard. Harvard's admission policy, first of all, Harvard admits 3.3% of applicants, which for those of us who played the $1 billion Powerball, it might feel like there's as good a chance of getting into Harvard as winning that. Obviously different percentages, but not great to get in. Their process involves a first reader who will review every application. So one first reader reviews every application, not the same person, but many readers. And they rank each application in 6 categories: academic, extracurricular, athletic, school support, personal, and then an overall aggregate rating on a 6-point scale, with 1 being the best and 6 being not as great. And a student that receives a 1 in every single category has a greater than 90% chance of admission, although it's obviously a very selective group that gets that 1 on every category. First readers can and do take race into account when they're scoring. Then every single application goes to an admissions subcommittee, which re-reviews applicants from specific geographic areas. So there's different committees for different geographies. And they also take race into account. And ultimately, they make recommendations on applicants for admission. Then everyone who's been recommended for admission goes to a full committee. That's 40 members of admission staff. And that committee votes on each candidate for tentative admission. And it's a majority vote. It reviews the tentative admitted pool then for racial composition. So it looks at whether or not that pool looks like the previous class that went to Harvard. So if there are, 20% of one race and 30% of another race in this pool, that's not at all what Harvard had the year before. They're going to try to adjust that incoming pool to look closer to those percentages. They also lop people off of the candidate pool, and the things that they use when deciding who to lop off and who not to is legacy status, which has come into its own sort of review in the press lately, recruited athlete status, financial aid eligibility, and race. So again, Harvard's goal in having an admitted class is to have it look like the class that went to Harvard the year before. UNC has its own interesting admissions policy that looks a lot like what the Supreme Court probably everyone thought was okay going into this decision. It admits 9.6% of applicants, so 3 times better than Harvard, still not a great chance of getting in. They have one of 40 admissions office readers review each application. They spend they do 5 an hour, so 12 minutes an application or so. Factors reviewed include academics, standardized test scores, extracurriculars, the quality of an essay, personal factors, and student background and race. Applicants are then recommended or not recommended for admission. And the way race is considered, it's added as a plus. If someone is, otherwise considered borderline for admission or maybe wouldn't have otherwise been admitted, they can get a plus based on their race. So during discovery, UNC admitted that it can have a significant impact on the recommendation for admission. After that initial recommendation, a school group review occurs, and that's a committee of experienced staff that review decisions of the admissions readers. They look at a scorecard on each person that lists their class rank, their GPA, their test scores, whether they're in or out of state, their legacy status, whether they're a special recruit, particularly for athletics, and their race. And here, again, racism is a significant factor in how UNC admits students. So what are the precedents? What has the Supreme Court done in the past in connection with affirmative action in the school admissions arena? So the first case that we look at is the Regents of University of California v. Bakke, and that involves UC Davis Medical School, where they admitted 100 students every year to train to be doctors. And the plaintiff there was a white man who said, I have better test scores than people who were admitted, who were, I think, African-American in this case, but it could apply to different minorities as well. And what happened in UC Davis is they actually had a set aside. They had a quota. They said 16 of our 100 seats are going to go to minority students. So they put them on a separate track. They said, if you're a white applicant, you're eligible for one of the 84 seats that is for white people. And if you are a minority applicant, you are eligible for one of the 16 seats. I don't think they ever gotten to the point of whether or not, if there was more than 16 people that they wanted to have that were minority, if they could have some of the white seats too. I'm assuming that was the case. But here, the issue was a white person claiming that they had been discriminated against, which is often how we see these things come up in the Supreme Court context in admissions, or another large class that feels like it's underrepresented. So the school, essentially said, we have 4 reasons for why we're doing what we're doing. They said, we want to reduce the historical deficit of minorities in medical schools. We want to remedy effects of societal discrimination. We want to increase the number of doctors working in underserved areas. And we think there's educational benefits to having a diverse student body. And then the Supreme Court got down to the business of deciding the case and writing about this. And there was 5 separate decisions that were written by 9 Supreme Court justices. And none of the justices could actually agree on the holding of the case, other than to say that they're willing to accept the argument that there's some benefit to having a diverse student body. Justice Powell addressed all 4 of those reasons for racial divide and essentially rejected 3 of the 4. And the 4 justices who concurred in his result didn't actually, according to the current Supreme Court decision, agree with the concept of having a diverse student body. They disagreed that Justice Powell's decision, the outcome of it, should be right. And there, Justice Powell indicated that he thought that race should be allowed to be a plus factor, an adding factor that helps someone get admitted. Then we get to Grutter versus Bollinger. That is the University of Michigan Law School. And there, this decision was made 25 years after Bakke, which is important when we start looking at the time period of which the court has been looking at these issues. The school was permitted to consider race, but not establish quotas and not insulate minority candidates or others from the admission process, and it couldn't set goals for a certain percentage of diversity. And the court warned that admissions policy should not be used to unduly harm minority students. And there it said you could still use a plus, but it can only be a plus. It can't be a negative to anybody. Now, the next is we'll talk about a little bit in the SSFA case. There, the court suddenly realized, came to a different conclusion that adding a plus to certain candidates necessarily in a zero-sum game means other candidates won't get admitted. And so it actually is a negative to those other candidates, according to the Supreme Court. It also, there's an important note that in Bollinger, the court said race-based admissions must end at some point. We're not going to have affirmative action forever, according to the court. And that was an important piece in order to get 5 justices on board with that decision. That was the Supreme Court negotiates among justices when it decides things. And that was something they had to negotiate in. It had been 25 years since the Bakke decision. And the court predicted that in another 25 years, the consideration of race in admissions should no longer be necessary. So now we get to the holding in SFFA, Students for Fair Admission versus Harvard. They noted that 20 years had passed since the Grutter versus Bollinger decision, and that colleges, in their view, had no plan to end racial preferences. They said, look, we said 25 or 20 years ago, this has to end in 25 years, and you guys have no plan to end it. So we're going to end it, essentially, because you haven't come up with your own plan. They said there's no way to measure the impact of a diverse student body on educational outcomes to know when goals of diversity have been met. So they said, look, this is an amorphous concept. How can we ever find out if you're actually achieving diversity? And then they attacked whether or not diversity actually increases the positive outcomes of the students. They said, we don't know if that's actually true. And you haven't given us any studies or anything to show that it is true. Ultimately, they also said that the racial classifications that are being used by the schools were too broad and didn't make sense. They attacked whether or not a certain group like Middle Easterners belonged in the white category, in the Asian category, or some other category. And they used a bunch of examples like that. They said, look, so the experience of someone of East Asian background versus Southern Asian background is very different. And by lumping all these people together, you're overbroad. And they also said that admitting minorities for the idea that they're increasing diversity is not quite the point of a diverse educational thought process. They said that not all minorities share a significant diverse or the same thought, the same way of thinking about things, the same viewpoint. And so ultimately the Supreme Court said that diversity for the sake of diversity is questionable. But, and this is an important but, the court left the door open for the consideration of the impact of race on an individual applicant. They said, look, you got to look at applicants not as a single race, not as a single group, but individually. And so Justice Roberts, in the majority opinion, said nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise. And ultimately, some colleges may decide that they want to know exactly that. And they may ask in student essays for students to consider that quote, how it has impacted, how has your race impacted your life, as a prompt for students to write about in their college admissions. Now, the Supreme Court also warned through Justice Roberts that even though we're going to look at the individual words of students, don't use essays as a workaround for this. So they're going to be a little skeptical, and we have to keep an eye on that one. It says a benefit to student to overcome racial discrimination, for example, can be tied to that student's courage and determination. So that's a personal characteristic that's not tied to their race, or a benefit to a student whose heritage or culture motivated him to assume a leadership role or attain a particular goal, but it has to be tied to the student's unique ability to contribute to the university. They said, in other words, a student has to be treated based on his or her experiences and not on the basis of race. So the question is, this is all in the admissions context. What does this mean for employers? And Laura is going to tell us a little bit about that.
Thank you, Curtis. So that's the big question. The SFFA decision applies to student admissions. And that, as Curtis very correctly explained, those decisions lived in a bit of a silo. They are decisions and precedent that apply only to student admissions. Our employment law cases exist in entirely different silos within judicial precedent. So we're going to take a look at that now. The first thing we need to distinguish between when we start to look at these cases is public employment versus private employment. They are subject to two different sets of statutes and constitutional provisions, and they have two different lines of authority. And then we're also going to make a distinction in just a minute between hiring and layoff, because affirmative action in those settings is seen as different. Okay, having trouble advancing. Let me try again. In the public sector, we are subject to the constitutional principle of equal protection. This is what Curtis was just bringing us through. So in that way, the SFFA decision does have at least an indirect impact on our analysis of employment law decisions and race consciousness in public employment. If a public employer wishes to use race to make employment decisions, it must first demonstrate that it meets all of the standards of equal protection and strict scrutiny. That starts with having a compelling governmental interest that it is serving by taking race into account. The US Supreme Court and most federal courts have not said, as a general matter, that diversity for diversity's sake in all segments of public employment is a compelling interest. So in many instances, a race-conscious decision in employment is going to fall down on the very first prong, because that public employer may not have a compelling interest to be doing what it's doing. Diversity has been recognized as a compelling state interest in very limited circumstances. For example, having a diverse police force has been found to be a compelling governmental interest. So very, very tiny segments of public employment, but not generally. Instead, if we're talking about any other segment of public employment, the compelling state interest would have to be remedying a history of past discrimination. So the governmental entity would have to show, I need to engage in this race-conscious decision, this plus factor, right, based on race type of decision, because I, as the governmental, and not just society generally, but I, as the governmental employer, this governmental entity has a history of past discrimination. Even if that can be satisfied, the means employed must be narrowly tailored. Curtis talked about that our recent SFFA decision was very tough on those colleges and universities, saying your program isn't sufficiently narrowly tailored. You can't explain how it is that what you are doing with respect to race and admissions is in fact serving this compelling governmental interest that you're talking about. So it's a very difficult standard to meet. But if it's met in those very limited circumstances, then race could be a factor. So we would expect that future public sector race-conscious decisions will meet under this US Supreme Court the same kind of very exacting and cool reception that we saw in SFFA. Title VII has actually been governed and is governed by an entirely different but closely related test. Under Title VII, the standards were set by two major US Supreme Court decisions, Weber versus the US Steelworkers, and a case Johnson involving a public school district. Those cases established that in a similar test, if a private employer is going to engage in a race-conscious decision, hiring decision, it has to show that it is necessary to remedy past discrimination. What it means in the private sector is showing a quote-unquote manifest racial imbalance between the workforce that the employer has and the available workforce in that area. And if what you are talking about are skilled jobs, well, then you're going to look at what is the available workforce that has those skills that you need to fill those positions. A manifest racial imbalance has been determined by the courts to mean at least 2 standard deviation difference between the private employer's workforce and that which is available in the geographic area. Then again, we have to have these kind of narrow means, right, to achieve the goals. This plan, this method of allowing a preference towards minority employees cannot unnecessarily trammel the rights of non-minorities. If all of that is met, then the employer may use race as a plus factor. Let me just briefly tell you how this came up initially in Weber. So back in 1979, there was an employer that had a workforce that was only 2% African American, where its available workforce in the area was 39% African American. And what the employer wanted to do in that case was to reserve half of its incoming new employee training spots for Black Americans. The other half would go to white Americans. In that case, and looking at that, the US Supreme Court said that's okay, that meets this test. The available workforce is clearly manifestly imbalanced, your workforce compared to the outside. White employees will still have the opportunity to become employees of this workforce, and it was limited in time. The idea was we're not going to do this forever. This is solely to kind of get us back into relative balance, and then we would abandon this thinking that we have remedied our past discrimination. The Title VII case law became even a bit more complicated. I'm just going to touch on this with a case involving disparate impact. There, a police force administered a test. White applicants did dramatically better than Black applicants. The police force wanted to disregard the test results, saying there must be a disparate impact here. We're going to be sued for disparate impact discrimination. And the US Supreme Court set up a standard, which is, again, a fairly stringent one. It's not enough to be worried that your normal hiring practices may have a disparate impact. There must be a strong basis in evidence that what you have done, employer, would be a disparate impact violation under Title VII. So even when those standards are met, either the equal protection standard or the Title VII standard for engaging in a race-conscious decision, the application of that is important. If we are applying race as a plus factor to a hiring decision, that is generally going to be okay, again, assuming that those standards are met, but not if it's a layoff decision, not if we are selecting non-minorities for layoff in order to maintain our racial balance or our racial diversity, and that has come from a decision from the US Supreme Court. The EEOC has issued guidance on these voluntary action plans. It very much tracks what we've talked about here. It must be a written plan. The employer must be demonstrating that it has engaged in the analysis that we've been talking about. Show me your imbalance. Show me your evidence that you, employer, engaged in past discrimination, and that is the reason for your racial imbalance in your workforce. And then if all of the other factors are met too, race may be used as a plus factor with respect to hiring, promotion, but again, not layoffs and not terminations. So what is the interplay here between federal contractors that have an affirmative action obligation? And some of this confusion is generating from the use of the same words, affirmative action, in so many different contexts. The OFCCP has on its website
I think Laura froze up on us. Hopefully she can get back on shortly. So while we're waiting, one of the questions I'm going to have for Laura is, oh, you're back.
I am.
All right.
Fantastic. My internet connection is unstable. So the OFCCP has issued a clarification on this point. The fact saying, so we've heard about affirmative action and using race as a plus factor in student admissions. Does that apply to us as employers? Can we use that to satisfy our affirmative action obligations for OFCCP purposes? And the answer from OFCCP is very clear that it is a no. And it sets this out. Those decisions, just what we've talked about, those decisions don't apply to employment. And OFCCP does not condone race being used even as a plus factor in employment decisions. Instead, OFCCP says if you are following affirmative action principles, you will be fostering a workplace that invites diverse applicants, that is free of bias, and that is how you will achieve racial diversity, not by exercising an actual preference on the basis of race. We also
ask a question before you jump on. So the court, in certainly in its most recent decision, said the plus factor shouldn't be used because it's a zero-sum game. Would that also be true in employment? Do you think that's the reason why you have that guidance saying shouldn't be using a plus factor?
Yeah, you know, it's interesting, Curtis, that zero-sum language is new. We hadn't heard that before from the U.S. Supreme Court. And as you said, in previous decades, that very principle of a plus factor had not been seen to be a negative, had not been seen to be an adverse action as against applicants in the non-minority group. But I absolutely think that same principle applies here. There aren't an unlimited number of engineering positions in any company, and a company only has one CEO. Therefore, the zero-sum principle is going to apply, and yes, it is going to be motivating, it seems to me, future decisions in the employment arena. State laws don't necessarily follow anything that we've been talking about with respect to these standards under the Equal Protection Law and Title VII. If we look at our own New York State human rights law, there is no manifest imbalance test that would allow a racial preference consistent with either equal protection standards or Title VII standards. The New York State human rights law does have a buried provision in it. I've not personally seen anyone attempt to use this, and maybe we will see it in the future. It allows a plan to be submitted to the Division of Human Rights, which would allow for a preference if the employer can show that there is a imbalance as between statewide unemployment rates and the number of employees that work for the particular employer. Back over to you, Curtis, because I think we should talk about whether or not any of these employment principles that I've just gone through came up in the SFFA decision.
And the answer is sort of. So as you know, as many of you may know, when the Supreme Court decides stuff, it's not just speaking with one voice. There's often dissents. There's also concurrences where judges agree with the result, but not necessarily the logic that got you there. And one of those concurrences comes from Justice Gorsuch in this case, where he almost puts on a hat as a litigant and making an argument that wasn't actually raised by the parties in the case. So he makes an argument that Title VI, which is part of the Civil Rights Act of 1964, just like Title VII, which Laura's just been talking about, would prohibit discrimination. And it would be, oh, can you go back? I don't know where we lost my spot. Would prohibit racial discrimination based on the clear language of Title VI, that no person in the United States shall on the ground of race, color, national origin be excluded from participation or denied the benefits or subjected to discrimination under any program or activity receiving federal financial assistance. And he says that Title VI applies to colleges that receive federal funding, including through federally backed student loans. According to Justice Gorsuch, Title VI creates an even stronger prohibition against racial discrimination than the 14th Amendment Equal Protection Clause. And he looks at that and compares it to Title VII, which is also part of that Civil Rights Act of 1964, and says, look, these were enacted at the same time by the same Congress. They have similar language. They must mean the same thing. And Title VII says it's unlawful for an employment practice for an employer to fail to refuse or hire or discharge an individual or otherwise discriminate against an individual with respect to compensation, terms, conditions, or privileges of employment based on race and a bunch of other factors. And also to limit, segregate, or classify employees or applicants based on race.
So
he's called out a little bit by some of the other judges. First, he's called out by Justice Roberts in a footnote in the primary decision of the court, saying that we think Title VI, if it has a stronger prohibition on racial discrimination than the 14th Amendment, is if something violates the 14th Amendment, then it certainly also violates Title VI. But Justice Sotomayor says, hey, by the way, we have a principle here at the Supreme Court. We don't raise arguments that the litigants themselves don't raise. And so for that reason, she's not going to address whether or not the Title VI issue should have ever been part of the court's decision. She said it shouldn't have been. And she does not expressly address the argument that Title VI and Title VII are analog from the same statute that must be read the same way. She just doesn't go into that analysis, so it's not necessary. But we could see enterprising litigants raise that argument going forward, that these are more exacting than even the 14th Amendment, and that to comply with the statute, even if something complies with the 14th Amendment, it complies with the Constitution, it's not compliant with congressional limits. So Laura, where does this leave us with respect to DEIB efforts?
So there's the big question. There's no question that the SFFA decision is the topic of broad societal debate right now. And that is going to have, whether it's a direct legal carryover, kind of as Curtis just walked us through, or whether it is simply the idea that all affirmative action in kind of all segments of society, including in the workplace, will start to receive more attention, and we can anticipate more challenge. Now, from other quarters, also more support, right? But certainly more challenge by those persons and groups who feel that those actions are discriminatory, and that DEI initiatives, at least some of them, should suffer the same fate that we just saw rendered in the SFFA decision. One of the first signals of this is a letter that has been issued by the attorneys general of 13 states. They are conservative states, of course. This letter was sent to the CEOs of all Fortune 100 companies. And these attorneys general band together in this letter to put those companies on notice of their positions with respect to preferences when it comes to employment. And I've pulled some quotes here out of the letter that I think very much capture the spirit and the content of it. In essence, saying, initiatives that your companies have been undertaking, we now believe are similarly illegal following the SFFA decision. They list the initiatives that these attorneys general see as illegal: racial quotas, selecting suppliers and contractors based on race, over preferential treatment to customers, quotas, right, or any other kind of hiring preferences. If your company previously resorted to racial preferences or naked quotas to offset its bigotry, that discriminatory path is now definitively closed. Your company must overcome its underlying bias and treat all employees, all applicants, and all contractors equally without regard to race. New York, as you might imagine, was not a signatory to that letter. We wouldn't expect New York to have the same view, but this is a very serious signal in many states about where this might be going. Now, DEI initiatives are not necessarily illegal. Frankly, even with that letter signed by the attorneys general. The question is, what kind of DEI initiative are we talking about? Some will be permissible, and others are going to cross that sometimes very murky boundary line into what we would consider now reverse discrimination. So the key is whether or not the DEI initiative resulted in an actual racial preference in hiring, promotion, layoff. If that occurred, and if the Title VII standards that we went through in the equal protection, the manifest imbalance, and then the equal protection strict scrutiny standards cannot be met, those DEI initiatives are very likely to be found to be unlawful. We also have to keep in mind as we move forward, and so many companies will continue to have a very strong commitment to DEI initiatives, that strong commitment to DEI initiatives, even if perfectly lawful the way implemented, could be used as evidence in any particular case to say, I think I didn't get that job. I think I didn't get that promotion. I think I got laid off, or I think I was unfairly disciplined because the company is pursuing these goals, and that may be some evidence of reverse discrimination. We are in an age right now where this takes conversation within the organization. We are talking about maybe different levels of risk than we had before following this decision. And companies will be deciding where they are from a risk tolerance perspective, from a mission perspective, from a value perspective. Businesses are going to come out, organizations are going to come out in slightly different places along that continuum. We don't know. I feel like when I'm at this part of our talk today and our discussion today with you, that I should have a ticker running under me that says, beware, these are predictions only. All of this is yet to be determined, because that is absolutely true. There are some things we feel that we can say with perhaps a little more definitiveness than others, and I've decided to color code certain kind of initiatives that from our perspective probably would be more in the kind of assuredly safe zone, and those that are going to require a little more scrutiny, a little more fact dependent, in order to be certain that they would continue to pass muster. It, generally speaking, is absolutely fine to try to increase the diversity of your applicant pool. The idea there is there's outreach to different communities, outreach to maybe historically Black colleges, media publications that may be targeted to one minority group over another, to advertise positions and to invite applications. At the end of that process, and this is really what OFCCP is trying to tell us in its facts, at the end of that process, the organization is to pick the most qualified candidate without racial preference. But the hope is that when you cast a wide enough net and you have a wonderfully diverse applicant pool, that the most qualified candidate, the successful candidates coming out of those pools, are going to represent racial diversity. But that's not through racial preference. It's not through race consciousness in the hiring decision. It's through having generated a diverse applicant pool. So here, are ideas of what very likely is going to be very permissible with respect to trying to increase your applicant pool. If, though, we move on to the application process and the selection process, and we start to talk about racial preference with respect to those who are selected for interviews, this is where things get a little less clear. It may be method dependent. Certainly, if all applicants are meeting the minimum qualifications for the position, and there are an unlimited number of interview spots, in other words, an employer is not denying an interview to a non-minority candidate in order to make room for a minority candidate, that is far more likely to pass a discrimination test than if minority applicants were being put into an applicant pool who did not meet the minimum requirements for the position, who had been screened out in an initial screening, or when putting them into an applicant pool causes someone else to be disadvantaged. You can also look at the diversity of your personnel committee. Most personnel committees, those doing hiring, again, assuming it's not their job, one can't exercise race preference in filling, hiring, recruiter spots, if that's the designated position within a company. But if instead there's kind of more of a committee process around this, applicants meet with multiple people within your organization, multiple employees within your organization, and there is no compensation that goes along with being on that committee, then an organization can highlight some of its racial diversity, its gender diversity, and show that off to candidates, and therefore increase the likelihood that there won't be implicit or explicit bias in the process because you have diverse people looking at a diverse pool of candidates. You want to look carefully at organizational statements. Generally speaking, those that are welcoming of diversity, they're encouraging of diverse candidates, minority candidates, underrepresented candidates. Those shouldn't be problematic, but there are statements that can go too far. They can start to sound like a preference. That's only who we're interested in. Or these positions we believe will be dedicated to. Clearly, that's going to be too far in terms of an organizational statement. An organization might want to promote its internal success stories. So if it has women, it has people from different countries and national origins and religions and races that have been successful in the organization, you might consider promoting those folks on websites so that individuals looking for jobs realize that this is an environment that is open and welcoming to diversity. You'll want to think carefully about training for employees. Again, generally that's going to be in the green category. We want to talk about our commitment to diversity. We want to talk about how we are welcoming in this workplace and we eliminate bias in our workplace. But you will want to think carefully about that messaging. I advise screening the trainer, understanding what the messaging is going to be, certainly. It's very important that personnel who will be engaged in hiring understand the legal requirements and understand where your organization has come out with respect to its risk tolerance and how far it's willing to push these boundaries or not. Hiring can still be based on subjective factors. We don't have to relegate this down to where'd you go to school, what were your grades, and how many years experience do you have? How did the person interview? Were they energetic about the position or not? What experiences are they going to bring to this workplace that is going to benefit us and would make them more likely to be successful in this position? All of that's fine, as long as it's not a subterfuge for racial or gender preference. Mentorship programs post-hire very likely will continue to be lawful as long as they're done the right way. They can't only benefit racial or gender minorities. There shouldn't be any direct tie to compensation or promotion. But if they're open to all, and the idea is we want to make sure every new hire here has a mentor, everyone has an equal chance for success, we'd put that in the green category. If there are going to be explicit advantages in promotion or training opportunities, we are going to make sure that at least 3 of our really select training programs that are highly competitive are going to minorities, racial minorities, gender minorities. That is very likely an explicit racial preference. So if you can't meet the manifest imbalance and the Title IX exception, and you can't meet equal protection, strict scrutiny, then that is problematic. That's not the way we want to go about DEI initiatives. Affinity groups, as long as they're not tied to any direct employment compensation advantage, and they're voluntary on everyone's part, and you can participate because you have an interest in that area, that should be okay. Many employers may go to diversity officer positions to demonstrate their commitment to diversity, again, create that welcoming environment that helps the employer to get a diverse pool of applicants, and to also ensure that once everyone is there, the company is living out its commitment to equal opportunity, harassment-free, bias-free workplaces and environments. You want to be very careful about any kind of bonuses or that are directly tied to leaders. If this is kind of, are you a good mentor generally? Are you a good role model within our company? Fine, great. Do you take time with new people to teach them and bring them along? That would be all right because it's open to everyone, but not if it is tied directly to how many women did you hire? How many minorities did you hire? So we are talking about a legal landscape that is absolutely in flux. We should expect more legal challenges, practices that businesses may have been engaged in and that have not been challenged. They've been accepted as part of the workplace culture, accepted as part of the societal values, may now be subject to challenge. This really does require consultation, deep thinking at your highest levels of your organization, and consultation with your legal counsel, which of course we would be happy to consult with anyone about. I'm just going to take a quick look at the chat here, Curtis, to see if there's anything that we can quickly tick off in the almost no time remaining.
There were several questions about whether or not the slides in the presentation will be available on our website. That's typically our policy. You should be able to find it there.
Yes. And in terms of what is allowable under the OFCCP regulations, it's about increasing your applicant pool, right? It's about if you find that you are not getting a diverse applicant pool, you are finding that your hiring practices are resulting in gross imbalance, then you are expected to examine that. Why is that? Do we have some bias going on here? Is there something about the way we are going about promotions that is not able to then be reflective of the diversity of society? But it's not to exercise a blatant racial preference.
So we had some questions about affinity groups.
Yeah. Mm-hmm. And there, I think any issue with affinity groups that limit participation based on race. Good question. It seems if it is not directly tied to benefits of employment terms and no one's getting anything more out of it in terms of, again, their terms and conditions of employment, then that's more likely to be acceptable. But if these are programs that are really, they are meant to advance individuals within that group, that's going to be, closer to our line of concern.
Right. And when Laura and I were talking about this before the presentation, she mentioned that when Monica Lewinsky became involved with her litigation against the former president, it shined a light on sexual harassment in the workplace. This decision may ultimately shine a light on this issue in the workplace. And that's why we're counseling people to be a little bit more cautious than they were in the past, to really think through things with their counsel. We're going to see a lot more decisions, I think, come out about these types of issues. And of course, our firm will continue to monitor those decisions. And as we see interesting or noteworthy things come out, we'll be having more webinars. We'll be putting out client releases. So please, follow up with us, follow what we speak about, because we're on top of this and we want you to be on top of it too.
Thank you so much, everyone. Have a good day.